Hi friends, welcome to the fifth edition of RERA My Perspective. Here we shall discuss all about how knowing registration is important to all, because this enables one to be empowered. Hence necessary you should know all about registration to be done by the developer. To recall, in the last 4 videos we looked at the background, what were the landmarks of this new legislation, the main features, definitions, etc., of all of which were important. Today we will discuss about the registration process of the developer and also cover interests, both of which are very important. So let us look at the slides. Section 3 and 4 deals with registration. So when RERA has come, it has become mandatory for all builders to register. Space is provided in the website. There is a large amount of data with documents can be attached, and they are provided with 44 or 50 slides. Section 3 says no advertising or marketing or booking or selling or offer till project is registered, which means unless you register the project, you cannot offer it for selling outside, not any ways, either through brochure, word of mouth, showing up sample flat, or even invite them. Nothing you can do. If you have to sell, you have to register. No promoter shall advise, market, book, sell, or offer for sale, or invite or to purchase in any manner any plot, apartment or building, as the case may be, in any real estate project or part of it. Suppose there is A, B, C, D, even the part of it, let's say B, in any planning area without registering the real estate project with the real estate regulatory authority established under the Act. This excludes redevelopment with no sale component, or with less than 8 apartments, or area less than 500 square meters. So what are the exceptions? Wherever there is no sale, and where there is a redevelopment or SRA schemes where there is no sale component, only then. If there is a sale component in those also have to be registered. Sale component will have to be registered. Or where there is less than 8 apartments, or where there is less than 500 square meters. Just one point over here I want to add up here. Of late in 2022, maybe about a month or two back, April, today we are in May, April or March, Supreme Court, Delhi RERA had come out with saying that there are a lot of issues with regards to 8 apartments or 500 square meters, because there are higher net worth individuals who are asking for a lower area, I mean less than 500 square meters, but they are getting cheated and they are not getting the money, or the project is not getting completed. So they want to include that also. Okay, section 4 regulates registration. Section 3 says you cannot register. Section 4 regulates the registration. It says you have to make the application for registration of real estate project. For registering, they have to upload all permissions, they have to take all the approvals, floor plans, project plans, amenities, documents, CC, what are the fitting and fixtures you are going to give, if you have taken any loan, if there is any mortgage, what are the current status of sold, unsold flat or parking lots, if you are holding any power of attorney or given power of attorney, that to be added up, all disputes, contracted details, pro forma of allotment letter and agreement letter, all documents pertaining to land has to give affidavit of above being true. All this will upload and say these are the true. Yes, to give an affidavit. This we also seen in the earlier slides. So you have a complete information, full project, last 5 years project details, complete flat details, development details, proprietor partnership limited company, what it is, names, photograph of promoters, current status, previous projects, blah blah blah. There's a lot of information that they have to give. Builder to give full cost of the project, cost estimated. There's lots under that also. Okay, so many information they have to give under, and this builder information is basically under section 3.8 registration rules. Now let's go to Now you know builder has to give. Just read this section, update yourself and see if your builder has given this information or not. You must also monitor builder. Merely saying somebody will monitor doesn't help you. Read this section, understand, because so many information they have to give. Have they given? Let's move to the next slide. He has to upload all copies of all documents, plans, layout, specification, approval, CCs and relevant details. Important, affidavit has to confirm correctness, legal title of land, that's very important, no encumbrance, time period for completion. He has to open a escrow account and give an affidavit towards that to keep 70% of funds received to be used only for the actual construction activity. Earlier you could have taken 100% off, now 70% is controlled by RERA through a process. He can be done only for actual work done, process given separately. RERA checks all these details and then only they give the certificate. He has to update information quarterly, get audit done within 6 months of year ending. He has to commit to take all pending approvals on time. So lot of responsibilities on the builder. Now let us look at interest. We have seen earlier in the earlier slide the definition of interest on the basis of interest. Let us look at it more deeply. This side on the right, what you see is the call out that basically is a definition. This is the definition as given in the Act. Okay, so you can read that out in the meantime. Interest shall be the same for LOT and builder. Builder cannot charge more interest in agreement. If he charges, you can claim the same interest which is mentioned in ZA, section 2 ZA, explanation 1. If he is charging more interest, you can also charge him more interest. But this interest will be on demand, not automatic. Now here I am coming to the nitty-gritties. If you are making a claim, you must mention that you have a demand on interest, because automatically interest will not come. If you don't say, the interest will not come. You have to make a claim saying that I demand interest because he has delayed, or he has not delivered the portion on time. Interest can be claimed if there is false advertisement. Section 12, see section 12, 14, 18 and 19, 4 are very, very important chapters, okay, sections. Section 12 says he can't make any false advertisements. So we'll come to a much more detailed discussion on section 12, 14, 18 and 19 because they are important. So that's the later videos will get it. So section 12 basically talks of any false advertisement. If he has made any advertisement and they are false, which is not to be good, then you can always claim interest, you can always claim compensation, interest and even withdrawal. Section 14, it talks about change in plans. If he is given you a plan, he is shown you a plan electronic, he cannot change it. Very clearly says he cannot change. Okay. Now if there is a delay in delivery possession, section 18 talks about that. We'll again see in much more detail on this. If there is a delay, you can claim refund, interest and compensation, and that has to be routed through normal authority and then the adjudicating officer. Again we'll come in much more detail on those, how to make the claim, because those are all very critical information. We should deal separately in those subjects. If you want to continue the project and you don't want to withdraw from the project, then you can claim only interest, and if you are having a loss, then you can claim compensation. Section 14, builder cannot change plans or layout after signing. Okay, everywhere he has to take individual written agreement if he has to change, and if it is for the flats, if it is for the entire complex, he has to take consent of 2/3 of the members. If builder defaults in a delivery, then LOT wants to withdraw from the project, builder has to refund the principal, whatever he has paid, plus interest from the date the promoter received the interest. From the day every installment you have given, from that day the interest will count. Okay. But again I repeat, you have to remember this interest all is on demand. It is not automatic. You have to lodge your claim saying that I demand that I get that interest along with compensation and refund of principal. So if you say it's as per law, then it will not come. If allotee wishes to remain in the project, he can only get interest from the date of default. Okay. Similarly, for the allottees, too, if there is a delay in payment, he has to give money or the interest to the builder on same lines like what the builder should get, that is MCLR plus 2%, which is SBI State Bank of India MCLR plus 2%, right? Now let us look at the balance part of it. Where builder defaults in payment or of interest or a penalty, interest including principal, compensation, etc., it can be recovered through enforcement and attachment. There is a provision that is already there, process is given. If it delays, you can always get it. Let me share, I have taken warrant against the builder. Okay, so there is nothing to worry, we can go ahead. Adjudicating officer, while adjudging the interest, shall take into account amount of loss, cost, nature of default, disproportionate gain, repetitive nature, etc. See, this compensation, etc., are to be adjudged by the adjudicating officer. What should be the quantum of the loss? That's why I said the thing has to go to the file has to go, the case has to be filed, and the file has to go to the authority, who will judge whether they has delayed, not delayed, and whether he entitled interest, and whether he has changed the plans, or he has put an advertisement and taken money, or there is a false advertisement. All those things they will judge. But when it comes to compensation and all, he has to transfer it to the adjudicating officer, who is a district judge, and he will look at it. So he has certain roles to do. He will go by section 71 and 72. Okay, under 72 he will check whether the loss, what is the type of loss, how it is caused, what is the nature of default, what is the disproportionate gain one gets, is it a repetitive nature by the builder. Based on that, he will give a judgment saying what should be the compensation. Role of adjudicating officer under section 71 and 72. Section 71 says for adjudicating compensation under section 12, 14, 18 and 19, AO is appointed, but here interest is not interest simpliciter but quas fe. What this means is, it is basically the interest is not penal interest. He has distinguished the interest. It's in a very famous case in Neil Kamal. This thing has been clearly clarified. Neil Kamal is the mother of all case laws. We'll deal that later on. That went into all the sections detailed, because the builders all challenged that. They didn't want the RERA to be implemented, so they challenged every section. So every section was taken into account and detailed out. So in case of this refund, what the judge held is that it is not a case of being simply interest simpliciter, which means basically from the date you have paid the money, the builder is having money with your money, and if you had the money, you would have also earned some interest. So it is that loss, it is just a compensatory for that part. Whereas if you are staying back in the project, but you are demanding, because of delay, you are demanding the interest, then that becomes penal. Therefore, penal is post, and compensatory is retrospective. Okay, so this you must remember. But compensatory in nature is retrospective, and that comes when you are withdrawing. Only when you are staying in the project, it comes post. So it says it is merely a compensation for use of money. Builder is obliged to pay interest due to delay. He is not unreasonable as allottee's money is used. It is not penalty or punishment. This has come out in Neil Kamal case. But normal accretion of the capital. It is a normal accretion of the capital is what the word they have used, which you cannot deny them. Okay, section 18 is to recompense allottee for depriving use of funds. Again, the next word is, if there is a section 18 is to compensate basically, to recompensate for what you are. There should have been an accretion, and therefore you need to be recompensated. Okay. Under section 18, interest is compensatory in nature. It is retrospective, and such cases can only be decided by adjudicating officer. Only adjudicating officer has the power to adjudicate compensation and interest qua se of compensation, which is basically retrospective. Interest and compensation under section 18 is compensatory in nature. and not penal. Also, only AO can decide this, and where there is a multiple relief. Interest paid when continuing the project under section 19 is, under section 18 is called prospective in nature. Okay. Now let us look at a little bit of the Nilkamal case, what it says. In this case, many points were raised challenging almost all sections of RERA, and every section was discussed, deliberated, argued, opinion of amicus curiae. Amicus curiae means a friend of the jury, friend of the court, obtained before deciding. One point was authority of AO, where it was decided that when compensation is involved, AO should only decide, nobody else. Clear? And interest paid under section 19 is penal in nature and prospective again. That's 19 is basically the allotee payment interest. Friends, today in this video we covered two very important areas, registration and interest. I am sure this bit of information will be very useful for many. And let me also get back the photograph back. Yeah. Okay. 1 minute. Okay. As this completes the video, so far we have covered the background and objectives, the landmarks of this new legislation, the main features, various important definitions, and today we did the process of registration by builders and the importance and interest. In the next video I shall discuss compensation. Compensation is very important from the perspective of allotee. You should know how compensation is given when you get. So please do watch out for the next video, and before I leave, I would just request you to please leave a comment and subscribe to the channel by clicking on the subscribe button. Please so you can share this knowledge with others, or you can ask them to also go by this video so that they understand.